Hello, and welcome to another edition with Immigration Attorney Brian D. Lerner. We are talking about the petty offense exception on these particular videos. We've gone over the rules and the requirements, but there's a few items in the petty offense exception that need to be looked at, some exceptions, some clarifications, and some specifics. Now, what if there is an undesignated probationary sentence? Does this fall under? Because let's say it could be more than a year theoretically, and it has been determined that a felony is punishable by more, which is punishable by more than 1 year imprisonment. That if there is an undeterminable probationary period, that will not fall under the petty offense exception. Now, what if, especially if you're in California, the particular crime falls under what is known as a Wobbler statute? That's where it could be either a misdemeanor or felony, depending on the facts of the case. Well, if the judge has determined or designates it as a misdemeanor and not a felony, then the Board of Immigration Appeal is bound by that determination and has to allow the petty offense exception. So remember, in this particular case with a wobbler, that means if it is a misdemeanor, then the crime, the maximum sentence will be less than a year. Of course, if it's a felony, the sentence will be over a year. And that's specifically listed in the statute. And again, if the judge has defined or stated that it is a misdemeanor, then for purposes of the petty offense exception, it does exist and you are not inadmissible. Okay, more in the coming videos.